Hi everyone, this is our Unit 6 video review. In Module 6, we talk about chapters 15, 16, and 17. I'm sorry, again, I'm wrong. Chapters 16, 17, and 18. Sorry, I got too many notes in front of me. We finish Module 6, in Module 6 we finish our discussion of the common law of contracts, which is super important when we talk about in Module 7, we talk about the UCC, because the foundation and the building blocks for the UCC discussion is all about the common law of contracts. That law is built off of the common law of contracts. So in finishing that up, let's take a look quickly at chapter 16 in your textbook, which is about assignment and delegation and third-party rights. Not a lot of information on your midterm about this. Assignment and delegation is a fairly complex subject matter, so if as you were reading that it's kind of confusing, you're not alone. It's included in there just to kind of round out the information on the common law of contracts, but I will not be asking you any questions about an assignment or a delegation. Let me tell you quickly the difference between the two, and then we'll move on from that. When I think of an assignment, I basically think of something that is a right, something that I would want to receive. So you can assign your right to receive money from someone else and have it payable to you. That's a good thing. You would want to have that. A delegation is when you are transferring a requirement or a legal duty to someone else. So if I were owed money from Tim, and Tim Tim was owed money from Bob. Tim may assign his right to receive the money from Bob and assign that right over to me. So Bob has to pay me directly. Notice how Tim is giving up a right, and I'm receiving a right. It's something that I might want to receive. It's an assignment. A delegation, for example, would apply if, say, Tim was supposed to paint Bob's house, and he decided not to do that, so he delegated that duty to me. Now I have to paint Bob's house. It's a duty, it's a responsibility. I might want to do it, but sometimes we don't want to always receive more work. So that's the difference between an assignment and a delegation, and you really don't need to know too much more than that. What you do need to know about from chapter 16 is the difference between intended and incidental beneficiaries, as well as the idea of vesting. Vesting means that you have a you have a legal right or legal interest in something that is current, that you now can go to court and try to enforce. Let me give you an example, because I think that's probably the easiest way to proceed. If you are an intended beneficiary, you are someone who is supposed to benefit from a contract. That is compared with someone who is an incidental beneficiary. If you're an incidental beneficiary, then you are only benefiting from the contract by happenstance. For example, if I make a contract with a builder to put a 3,000 square foot addition on my home, that would make my neighbors really happy because their property values may go up a little bit. They would be incidental beneficiaries. Are they a party to the contract? No. Are they intended to benefit from the contract? No, they are not. They are only incidental beneficiaries. So they do not have any rights that have vested. They can't go to court to enforce that contract if the builder or I decide not to proceed with the addition. However, if I take out a life insurance policy and I name, say, my aunt in that life insurance policy, if she decides that she wants to enforce that life insurance policy, she is an intended beneficiary. So she has a vested right to go to the court and ask for that insurance policy to be paid out to her. That's the difference between the two. And we look at that at the time of contracting. Was this person intended to benefit from the contract? One is yes, one is no. It just depends on the facts and the detail. More important for our discussion in Module 6 is a discussion of chapters 17 and 18, because they really kind of round out the full discussion of the common law of contracts. In chapter 17, we are discussing different ways that a contract can be terminated. The first part that we look at are called conditions. Conditions are either conditions precedent, concurrent, or subsequent, and these are events that can happen that can affect the ongoing nature of a contract. For example, a condition precedent has to occur before a contract is formed. A condition precedent could be conditioned upon financing. For example, if you're going to buy a new car, you cannot buy that car if you don't receive financing first. Therefore, the contract will never go through if you don't meet your condition precedent. Condition concurrent is really just two things happening at the same time. You get the keys to the car at the same time that you pay money and buy the car. Those are two inherent or implied conditions concurrent. A condition subsequent is something that happens after a contract has already been formed that stops or terminates the contract from happening. Suppose, for example, I make a contract that says I will pay you $10,000 a year if you perform the landscaping for my yard, including snow removal in the winter, on the condition that if you ever take full-time employment, the contract will stop. So if this person then goes out and gets a full-time job, that is a condition subsequent that has been met, and the contract by its terms has been terminated. When we talk about termination of a contract, the most typical way that a contract is terminated is by complete performance. The parties both do their part and they end up paying the money or giving the goods or the services, and the contract goes through without a hitch. However, there are some times when one of the parties or both are what we call in breach of contract. And breach of contract means that the parties have not fulfilled all of the terms of the contract. There are two different types of breach, and you should be aware of them. One is material breach, and the other is minor breach of contract. A minor breach of contract means that there was some technical part that was not met, but it is a minor aspect of the contract. The essential elements or the most important things have been fulfilled. For example, if I make a contract for the purchase of a home, and there's a tiny shed that's supposed to be built in the back as well, and it's supposed to be painted red. Suppose the contractor builds the home and even builds the shed but does not paint that shed red. That is a minor breach of contract. The difference is important because if you are in material breach of contract, the other side can suspend performance. They don't have to pay until things are resolved. If it's only a minor breach of contract, the other side still has to pay and just deducts the amount that would take it to come into fulfillment with the terms of the contract. Material breach of contract also has to be done in good faith. Minor breach of contract has to be done in good faith. So you have to worry about that as well. If you are in material breach of contract, we will look at something called the substantial performance doctrine, which means, did the person who is doing the work, the goods or the services, did they substantially perform their contract? If the answer to that is yes, then you're falling into the category of minor breach of contract. If the answer is no, then it is a material breach of contract. If the parties decide that they want to end their contract or to change some of the terms of the contract, we call that rescission. If you want to rewrite some terms of the contract to make it something more in line with what you thought you were going to do, we call that rescission of contract. If you decide that you want to kind of scrap the old contract and enter into a new contract, or have a contract with a new party, we call that a novation, where you have an original contract between two parties, you cancel that out, and you substitute one party for a new party to the contract. Sometimes we have things happen and contracts become impossible to perform. Impossibility of performance means that there is no way for you to perform. For example, if you are to supply orange juice to a distributor, and suppose your crops are ruined because of a natural disaster, you cannot produce the orange, or you can't get the trees to produce the oranges to create the orange juice to get to the distributor. It's impossible. Parties can be let out of contracts because of impossibility of performance. More likely, though, in a business setting, we have something called commercial impracticability. There are times the law recognizes where it's not worth it financially to go through with a contract. And in cases like that, commercial impracticability can be used as a way to let parties out of a contract where it would really jeopardize the ability of the company to continue to stay in business. Okay, the other one is frustration of purpose. There's an old case where a party had bought tickets to a parade in England, and the parade was canceled, and they wanted to get their money back for the seats that they had purchased along the parade route, because the purpose of the contract had been frustrated. And the court said, yes, there's no need to have a contract for something that's not going to take place any longer. So that person was allowed to terminate that contract. Your last chapter on the common law of contracts deals with remedies, and remedies is all about show me the money, right? So how do you enforce a contract, and how do you decide what remedies to select or to ask for once you have a breach of contract? If there is a breach of contract, you can see my dog in the background. If there's a breach of contract, the non-breaching party will oftentimes sue to receive what they would have gotten had the contract go through. We call that the benefit of the bargain. And the most typical type of a remedy there is compensatory damages. Compensatory damages will basically restore a person to the position that they would have been in had the contract gone through. We then have other ones like consequential damages, which can account for lost profits. That happens in business oftentimes, and you just have to make sure that the profits are not speculative, like so remote or unprovable that you really can't rely upon what the documentation is with any certainty. Of course, we also allow for other types of remedies as well, but in the state of Washington and in many states, punitive damages are not really allowed in a breach of contract action, so that's something for you to remember. We use punitive damages in tort law, and they're allowed there in many states, except Washington is not one of them. But in contract law, punitive damages are not really appropriate. The other thing that I forgot to mention in the section on breach of contract is the idea of anticipatory repudiation, and that occurs when a merchant or someone in business gives the other party notice that they will not be able to perform the contract on the stated date in the that was stated in the contract itself. Anticipatory repudiation allows the non-breaching party to sue immediately for breach of contract, even if the contract was not supposed to be due for another 3 or 4 months. They can sue as soon as they receive notice of the anticipated breach, or they can actually wait to see if the other party can perform. They have the option to elect which way they want to go. Also, they can go ahead and find a deal elsewhere, and if they have to pay more than they would have paid with the original party, they can sue for the difference. So that's all falls under anticipatory repudiation. That's your material for Module 6. You're doing a great job. Good luck on your midterm exam, and let me know if you have any questions.